for fair trial. Because I will file a petition, I will not even heard, and 3 judges or 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184.3 will become totally redundant. This is my point. Therefore, that is section 3. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court.
Do you object? For say I object to this provision, or you endorse it?
I will say this, sir, that in matters of interpretation of the Constitution, when you are all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or but not 7, I object to this thing that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this otherwise the Constitution section 4 says something? We should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges. Because this is very strange, because all judges are equal. Your Lordship is the first among the equal, but every other judge of the Supreme Court has the same powers and the same equivalent. So I think this thing, you cannot less than 5. Then there is a question of appeal, and which is a very relevant point.
As I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I noted this thing.
Yes.
Your Lordship, because I would not be able to explain my shortcoming. On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the Parliament. About how the benches are.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, this is your. No, sir, I am saying the thing that under 1980 rules, that power had been given. If all of you sitting together feel that under 191 that it should be changed, then it is your function. It is not a function of the Parliament.
Now let's proceed.
I'll do on that. That's the point which needs to be said. 5 is appeal. Yes, sir.
On section 4. If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution, because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendments? Can Parliament do something where the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
मैं एक सवाल पूछ लूँ आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ
जी सर।
मैं सिर्फ सिंपल सा आपकी जो समझ सारा कानून अगर यही सारा को फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुन लीजिए, सवाल तो सुन लें
जी जी
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी।
नहीं नहीं ऐसे नहीं है।
आपने ये कहा था कि ये सारी चीजें करो, लेकिन
नहीं सर, ऐसे नहीं
सुप्रीम कोर्ट
नहीं
में
सर, ऐसे नहीं।
पहले बस नोट कर लिया, मेरा बात में
मैं नोट कर लिए जब सुप्रीम कोर्ट
नोट जो कर
आप
लिया
जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब
ठीक है, अदरवाइज तो आपकी मुश्किल काम हो
नहीं मैं I am quite I am very
नहीं, आगे बढ़ते हैं।
I have worked with all of you sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
Problem नहीं। I understand what Shah Sahab is suggesting and saying, and yet I mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked, independence of the judiciary is a recognized fundamental right.
Yes, sir.
So the question, surely, there is a question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have the legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word very deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution. The Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
आप नोट कर लें। If I will really request my colleagues that they are making, including myself, are making your life impossible.
I'm
Please, no, you are very fine.
I'm
No.
learning.
No, we are not here to teach you anything. You are here to help us. Now, please, I'm not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we're stuck with section. We're not making progress. Please continue in your way.
आगे बढ़ते हैं। Let me say this. Section 5 से आगे बढ़ लीजिए।
Another question with regard to appeal. आप देखें, हमारे पास ऑलरेडी एक डिक्टेटर का ऑर्डिनेंस था, लॉ रिफॉर्म ऑर्डिनेंस 1972, उसके तहत आर्टिकल 199 के लिए अपील प्रोवाइड की गई बिफोर 2 मेंबर एक्शन। वी आर फॉलोइंग इट। क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहाँ तो अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 फिर आर्टिकल 183 84(3). तो ये क्या
Sir, it is not to be answered what Parliament can do and what Parliament can do many things. My Lord has said so, but there is a procedure provided will answer that.
भाई साहब अभी जवाब की जरूरत नहीं है।
I will not answer.
पहले एक्ट को
Section 5 से आप they have collected 100 questions.
The law reforms ordinance of
How you will
1972,
answer?
this is the question to you. Regulated right of appeal, so within the High Court itself, intra-court appeal, was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clause is there only in respect of the Supreme Court. Law reforms ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clause was relation to Supreme Court. Question: is therefore the Law Reforms Ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. In relation to the Supreme Court, where there is a very clear law.
Mr. Noted, sir. And appreciation. Section 5. An appeal shall lie within 30 days from an order of the bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under clause 3 of Article 184 of the Constitution prior to the commencement of this Act, provided that the appeal under this subsection shall be filed within 30 days of the commencement of this Act. I'm not going to analyze it. I have my serious objection on this, and I will.
So what you have to do, you're saying I'm not going to do it.
Well,
you challenge the law, you have to challenge it.
Appeal shall lie within 30 days.
Have you read the English of it? What's wrong with it? Tell us that.
As far as section 5 is concerned,
Is it good, is it bad? First tell us that.
Well, it says appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of 184. May I specifically submit that if an appeal is provided against a decision under 184.3, then why is this not they included in clause 2, whereby my 184.3 application will be disposed of?
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us what's unconstitutional about it.
Then let me explain it